Respected Chief Guest of the Day, Sri V. Sudheesh Pai, respected senior lawyers of the Kerala as well as Karnataka Bar, including my dear senior advocate G.K. Shugur from Karnataka, and honorable judges who have assured that they may join this webinar after the court hours, honorable judges of the High Court of Kerala, and all other lawyers, Kerala lawyers as well as Karnataka, who have expressed their desire to join this webinar. Today, we are extremely happy to have this function, especially when this day is the first day of the Malayalam New Year. That is, it is first day of Chinyam, the first month of the New Year as far as Malayalis are concerned. So it is an auspicious day, and the year Malayalam era is 1196 Malayalam era. We are extremely glad and privileged to have with us one of the eminent jurist and author, Sri V. Sudheesh Pai, to enlighten us on the subject freedom of expression, media, contempt, nuances and limits. On behalf of the Kerala High Court Advocate Association, I extend to you, sir, a warm and hearty welcome. I am told that some of the honorable judges of the Kerala High Court will join the webinar after the court hours. And anticipating that joining, I welcome the honorable judges also. I extend them hearty and warm welcome. I also welcome all the participants. Many members from Bangalore Bar is also joined, I understand, and as well as the members from the media, as well as the members of the other Bar Association of Kerala. They are also expressing their desire to join. So we have permitted them to join, and we have sent the email ID and password. And I welcome all the participants. Thank you.
Namaskaram and a very good evening to all of you, and also a very happy new year on the 1st of Chinyam today. I am deeply sensible of the honor of being asked to speak to you today on the subject freedom of expression, media contempt, nuances and limits. I am grateful to the Kerala High Court Advocates Association for this privilege and opportunity. The subject is, of course, of abiding interest and importance. However, we should steer clear of any allusions to contemporary events or proceedings and not impart a sense of universality to any particular individual experience. The importance of freedom of thought and expression in a democratic society can never be overemphasized. The ultimate good in a free society can be reached only by a discovery of truth, and that can be achieved only by a free trade in ideas. Those are the words of Justice Holmes. And as he elegantly put it, the best test of truth is the power of thought to get itself accepted in the competition of the market. And freedom of thought is not only freedom for the thought we like, but even more, freedom for the thought that we hate. Public criticism is essential to the working of democracy, as the Supreme Court pointed out in Bennett Colburn. The very foundation of constitutional government lies in the belief that changes, if desired, may be brought about by peaceful means. It is settled that there are certain well-defined and narrowly limited classes of speech, the protection and punishment of which has never been thought to raise any constitutional problem. The Constitution does not contemplate protection of defamatory statements, nor speech or writing detrimental to national security or public good. The freedom is only to ensure that the general will of the people, as John Stuart Mill called it, is made known, that government may respond to it and changes may be obtained by peaceful means. But it is also important to ponder over whether the media has become a victim of its own success. Lippmann warned long ago that the real danger to the media springs not so much from the pressures and intimidations to which it may be subject, but from the fact that journalists can be captured and captivated by the company they keep, their constant exposure to subtleties of power. The media is highly commercialized and journalism is fast becoming a business more than objective reporting. The freedom of the media has to be with the no less valuable rights like the right to privacy, the right to presumption of innocence until proved guilty, the right to a fair trial, all of which have been recognized as guaranteed human rights, and which they have to meet in the larger public interest. The Supreme Court also has highlighted the need for evolving a balance between free media and the administration of justice. The Supreme Court has also highlighted the need for finding an acceptable constitutional balance between free media and the administration of justice. Now, equally important is the need for a fair balance between freedom of expression and of national security. It is not uncommon that many times we see an entire police action or military operation being telecast, giving opportunity to the opposite camp or those indulging in anti-national or anti-social activities to get a clear picture of the plan and operations against them. Indeed, what happened with the telecast in November 2008, when there was a terrorist attack in Mumbai, is a case in point. Article 19.2 enables curtailing the freedom under 19.1a, but even without such restrictions, the media itself should show enlightened self-restraint in the larger public interest. The need to balance freedom of expression with other societal interests and the larger public good is a constitutional necessity. As the Supreme Court has pointed out, if maintenance of democracy is the foundation of free speech, society is equally entitled to regulate freedom of speech by democratic action. Consequent upon this is the need to foster fraternity, one of the most cherished constitutional goals. This has been adverted to by the Supreme Court in a large number of cases. Indeed, in the Constituent Assembly, Dr. Ambedkar spoke of liberty, equality, and fraternity as forming a trinity. And without that sense of brotherhood and oneness, it would be difficult to maintain the nationhood of the country. It is therefore equally the responsibility and function of the media as of the wings of the state to foster this sense of fraternity. The Fesliyan Committee made certain recommendations regarding the role of the media. This was in the case of destruction of public property and public and private property in 2009. It was suggested that professional journalists should function as trustees, seek the truth, report with integrity and independence, and there must be self-regulation based on the principles of impartiality and objectivity in reporting so as to ensure neutrality. And a balance must be maintained, accepting and accommodating all points of view. Now, it is undeniable that freedom is like oxygen. We know its value only in its absence. Sunlight is said to be the best disinfectant. In the unforgettable words of Charles Bradlaugh, better 1,000-fold abuse of free speech than denial. The abuse dies in a day, but the denial slays the life of the people and entombs the hopes of the race. But then calamities occur in human affairs because of a clash between values, each of which is important. The crucial need is to strike the right balance between conflicting values and interests. One important determinative factor that should weigh in the matter of discussion and coverage by the media, I would submit, is what good will ultimately come out of it. Every statement of fact may not qualify to be the truth. As the Mahabharata tells us so sagaciously, Yat bhuta hitamatyantam tat satyam iti dharana. Truth is that which promotes the general good and welfare of the community, of the society as a whole. The task of balancing various competing claims and conflicting interests is indeed delicate and challenging. At stake are fundamental values that cannot be allowed to be diluted consciously or otherwise. This is one of the greatest challenges to the media. It is an equally great challenge to the judiciary when the occasion arises and it is called upon to pronounce on these various aspects. The courts do this by applying the test of proportionality to determine the reasonableness of restrictions and their permissibility. It is to be remembered that neither the judiciary nor the media has such stock of social, economic, and political wisdom to provide solutions to all problems of the people. The people must work them out themselves. The role of the media could be likened to a lamppost which sheds light on the path. It is not to serve as a crutch for a limping society to amble on. In different and changing times, one thing holds true for all institutions: they cannot afford to be clever. To paraphrase the words of Peter Drucker, in times of crisis, adherence to truth and time-tested values may not ensure success, but not doing so guarantees failures. Now, as I said, as the Supreme Court said, public criticism is essential to the working of democracy, and this includes criticism of every institution and organ. This freedom takes within it the right to comment upon and criticize judgments, as also conduct and behavior of judges. It's an indispensable part of the accountability process and very basic to our system. This is too well established and too sacrosanct to be allowed to be stifled or interfered with. Judgments sometimes leave one totally aghast. It is elementary that a judgment must be properly reasoned. The conclusions must flow from settled premises. The facts and the ground reality should be taken note of properly. But sometimes these desiderata are absent, and we have orders without factual foundation or legal support. This cannot be acceptable. Many judgments and orders are unanimous. While unanimity is welcome, it must be remembered that judges are there not simply to decide cases, but to decide them as they think they should be. They are to exercise their individual mental and intellectual faculties and not have a herd mentality. Justice Hidayatullah, in his Alladi Memorial Lecture in 1989, spoke of supine judges who are not good for the health of the system. Intellectual integrity is more clearly seen in a dissent, and not often when a judge shelters behind a majority opinion. We cannot forget that under our system, one of the functions of the courts, particularly the superior courts, is to enunciate general principles as pointers to law's future development. This is best achieved by delivery of more than one judgment. Lord Reed, regarded as perhaps the greatest judge of the common law in the 20th century, was wholly against single judgments in appellate courts. He emphasized that single judgments tended to be treated as a code, while the function of the courts is to enunciate principles. Multiple judgments help this cause better. It is multiple judgments which provide the wellspring of ideas from which the common law draws its vigor and vitality. Now, to say that judgments and orders should not be criticized and must be complied with, at sometimes under threat of contempt, is a death blow to the rule of law. It's a negation of all that we have fought for and all that this nation stands for. Thomas Paine said, in absolute states, the king was the law. In free states, the law must be and is the king. That is the desideratum of the rule of law, which the tribute paid by power to reason. Whatever pleases the emperor has the force of law, it has been rightly proclaimed, is not an article of democratic faith. Adapting this, one might say that whatever the courts say, even when it is without basis or principle, is law binding to be implicitly obeyed without a comment or criticism, is also not an article of democratic faith or judicial integrity. Fair and robust criticism should not only be not unwelcome, but should be considered necessary, healthy, and welcome. One recalls Sirvai's biting criticism of the majority opinion in the UP Assembly case, the privileges case, Keshav Singh, where in his book he concludes the discussion of the case and says that his discussion has showed at the majority opinion as the most one-sided judgment, and for the 6 judges in the majority to say that they would decide the matter in a spirit of free, detached, objective inquiry must appear hypocritical to the reader. It was not frowned upon. Lawyers, practicing and academic, ought to imbibe, nourish, and carry forward the great tradition of scholarly critics, subjecting judicial power to the restraints of reason, skeptical analysis, or philosophical inquiry. You cannot but recall Professor Granville Williams' stringent criticism of the House of Lords for its decision in Anderton versus Ryan, and the Law Lords' response to it in R versus Shivpuri. Professor Williams said, I quote, "The tale I have to tell is unflattering of the higher judiciary. It's an account of how judges invented a rule based upon conceptual misunderstanding of their determination to use the English language so strangely that what they spoke by normal criteria would be termed untruths, of their invincible ignorance of the mess they had made of the law, and of their immobility on the subject, carried to the extent of subverting an act of parliament designed to put them straight." This was in an article, "The Lords and Impossible Attempts," published in the Cambridge Law Journal, volume 45 in 1986. What is more significant is the Law Lords' response to this. Lord Hailsham, Lord Chancellor, presiding in R versus Shivpuri in the very same year, said, "There is obviously much to be said for the view to be expressed by my noble and learned friend Lord Bridge, that if a serious error embodied in the decision of this House has distorted the law, the sooner it is corrected, the better." And Lord Bridge, giving the leading opinion for the unanimous House, overruling its earlier decision in Anderton versus Ryan, said, I quote, "I cannot conclude this opinion without disclosing that I have had the advantage since the conclusion of the arguments in this appeal of reading an article by Professor Glanville Williams. The language in which he criticizes the decision in Anderton versus Ryan is not conspicuous for its moderation." Please mark the words, the language is not conspicuous for its moderation. But kindly mark the next words too. "But it would be foolish on that account not to recognize the force of the criticism, and churlish not to acknowledge the assistance that I have derived from it." So this is how the House of Lords responded. Critical legal literature would help courts to look at matters differently when required. It should, to borrow Lord Diplock's felicitous expression, alter the habits of the minds of judges. Lord Diplock was referring to the enormous influence that Professor Goodhart inserted on generations of judges He had been for 50 years, from 1925 to 1975, the editor of the Law Quarterly Review. In his Lincoln Day address in 1898, Justice Brewer of the US Supreme Court perceptively said, "It's a mistake to suppose the Supreme Court is either honored or helped by being spoken of as beyond criticism. On the contrary, the life and character of the justices should be the object of constant watchfulness by all, and its judgments subject to the freest criticism. The time is past in history of the world when any living man or body of men can be set on a pedestal and decorated with a halo. True, many criticisms may be, like their authors, devoid of good taste, but better all sorts of criticism than no criticism at all. The moving waters are full of life and health. Only in still waters is stagnation and death." Unquote. Therefore, criticism of the judiciary and the judges is neither dangerous nor undesirable. The benefits of freedom of expression are strong in this context also. In fact, David Panic, in his beautiful book, Judges, writes that criticism of judges will not damage the rule of law. It may, by identifying the defects in the system, promote the cause of justice. And the Salmon Committee put it, the right to criticize judges may be one of the safeguards which helps to ensure their high standards of performance. Justice Albie Sachs, that great revolutionary in the African freedom struggle and then a judge in the Constitutional Court of South Africa, said this in a judgment: "If respect for the judiciary is to be regarded as integral to the maintenance of the rule of law, such respect will be spontaneous, enduring, and real to the degree that it is earned, rather than to the extent that it is commanded. One cannot understand what can be wrong or objectionable in discussing, commenting upon, and assessing a judge's ability, performance, and reputation. Unless and until this is done, I submit, all talk about a great, fearless, and independent judiciary is absolutely meaningless. If the conduct, behavior, and performance of presidents and prime ministers, a whole host of persons at different levels in various fields of life, can be commented on and criticized, there is no reason whatsoever why the performance of judges and their conduct on and off the bench cannot be. It ill befits anyone functioning under the Constitution and the law to claim such immunity. Judges are as human and fallible as anyone else under the bright sun. The Almighty does not share his omniscience or infallibility with humans, including the judiciary." Indeed, at the very beginning, the Supreme Court rightly and wisely cautioned that judges should never be oversensitive to public criticism. I have in mind the judgments of Justice Bijan Mukherjee in Batina Ramakrishna Reddy and Brahm Prakash versus State of UP. This is what the learned Chief Justice said: "Reflection on the conduct or character of a judge in the discharge of his judicial duties would not be contempt. Such reflection is made in the exercise of the right of fair and reasonable criticism regarding the public acts done in the seat of justice. It is not by stifling criticism that confidence in courts can be created." One cannot but refer to the Templeman approach. After the Spycatcher case, this Attorney General versus Guardian newspapers, the three law lords who were in the majority were portrayed in a cartoon in the Daily Mirror with the caption, "Three old fools." The court took no notice or offense. Lord Templeman, one of the three majority law lords, remarked, "They were three in the majority, which was absolutely correct. They were not young by any standard, and whether they were fools or otherwise is a matter of opinion and perception, and it is no contempt." Following the infamous judgment of Bush versus Gore in the American Supreme Court after the 2000 presidential election, the five old men amongst the nine, the five majority judges, were severely criticized in the strongest and vilest terms by leading academicians in law journals and books. In fact, you have that beautiful book, Supreme Injustice, by Professor Alan Dervashes. But no offense was taken or contempt initiated. Much more recently, in 2018, the Daily Mail published the photo of the 3 judges who issued the Brexit ruling with the caption, "Enemies of the people." No notice was taken. How relevant is the contempt law today in a free country where criticism of judiciary is inevitable? Judges have vast powers. People cannot and will not remain silent or mute spectators about the exercise of such power. Just as decisions of other branches incur criticism, judicial decisions also would have to be amenable to the same. The concept of independence of judiciary takes many queer forms, but it cannot be an alibi for stifling any talk. Indeed, Justice Holmes refused to look upon any institution, including the Supreme Court, which he adorned for 31 years, as a grand lama, and believed that every institution must earn respect through the test of truth. Justice Khanna observed with great insight, the strongest weapon in the armory of the judiciary is its unsullied image, the esteem it evokes, the confidence it enjoys. Reference is sometimes made to the contempt power of the judges to command respect. This perhaps is apt to mislead. Contempt of court, as observed by the great jurist Lord Denning, should not be a means to uphold our own dignity. This must rest on surer foundations. We must rely on our own conduct itself to be its vindication. Believe me, public confidence in the judiciary is not strengthened by deterrence of criticism. Contempt of court has been described as the Proteus of the legal world, assuming a variety of forms. But we must remember, we are not subjects of a king, but citizens of a republic. The king is the fountain of justice in England. In a republic, all institutions, including courts, derive their authority from the people. The Indian approach must be more in consonance with the freedom of speech and expression granted by the democratic Republican Constitution, permitting criticism of every institution, including the judiciary. This is what Justice Krishna Iyer said in Bardakanta versus Registrar Orissa High Court, and he continued, a vague and wandering jurisdiction with uncertain frontiers, a sensitive and suspect power to punish vested in the prosecutor, a law which makes it a crime to publish regardless of public good, if not properly delineated and defined, may trench upon civil liberties, and so the superior courts, as protectors of our freedoms, must vigilantly protect freedom of speech, even against judicial umbrage. No discussion on this subject will be complete without mention of Justice Matthew's classic dissent in the Kerala High Court in Narayan Nambiar versus CMS Namboodiripad. Justice Matthew did not go with the majority, which held as contemptuous this statement of the Chief Minister regarding judges and their preferences. He did not agree with the views of the respondent, Namboodiripad, but defended his right to hold and articulate them. While he did not share the view that judges in their judgments should express the popular will, he believed that the blast of the theory or the deductions therefrom need not jolt the judges out of their moorings at this late hour. Judges must learn to transcend their own convictions and to leave room for much that they would hold dear to be done away with, short of revolution, by orderly change of law. They must not forget that what seems to them first principles are believed by half their fellowmen to be wrong. Justice Matthew was quoting Justice Holmes from his collected legal papers. And he said, the court by its pronouncement today is interfering with free trade in ideas and their competition in the market, to that extent with the democratic process. I do not think we are the best judges of the truth of the matter because of the nature of the allegations, the possibility of our bias, and the summary nature of the proceeding. He insisted that courts should not be oversensitive of criticism of themselves because they are guardians of the liberty of the people. Unfortunately, no judgment of the Supreme Court has considered Matthew's great dissent, but we must remember that Justice Krishna Iyer's leading judgment on Mulgaoka is nothing but Justice Matthew's views reiterated without express reference to it. We must also bear in mind these insightful observations of Justice Frankfurter in Bridges versus California. This has also been referred to and quoted in a number of Supreme Court judgments. Having said certain things, he continues, courts and judges must take their share of the gains and pains of discussion, which is unfettered except by the laws of libel, by self-restraint, and by good taste. Nor should restrictions be permitted that cramp the feeling of freedom in the use of tongue or pen, regardless of the temper or the truth of what may be uttered. Since courts are also, although representing the law, are also sitting in judgment as it were on their own function, in exercising their power to punish for contempt, it's better always to err on the side of tolerance and even disdainful indifference. David Panic very rightly says that even if the criticism of the court would have an effect on a judge's action, the offense of scandalizing the judiciary must be abolished. Like all other public servants, judges should accept criticism as an occupational hazard. This is what I would very respectfully reiterate. He goes on to quote Judge Jerome Frank, who was a judge of the US Court of Appeals. Some politicians and a few jurists urge that it is unwise or even dangerous to tell the truth about the judiciary. Jerome Frank sensibly explained that he had little patience with or respect for that suggestion. I am unable to conceive that in a democracy, it can ever be unwise to acquaint the public with the truth about the workings of any branch of government. It is wholly undemocratic to treat the public as children who are unable to accept the inescapable shortcomings of man-made institutions. It's a mistake to try and to establish and maintain through ignorance public esteem for courts. This was said in 1949. The dubious and controversial scandalizing the court of illegitimate ancestry and the Judges Protection Act 1985 should be done away with. Now, when I say dubious and controversial, these are the words of the great authors, Bory and Law, in their Contempt, Law of Contempt. You get this expression at page 331 of the third edition. It is dubious because it originates from a dictum of one judge, Justice Wilmot, in R versus Alman in 1765, and controversial as the dictum was recorded in a judgment that was never delivered. Therefore, it's not a judgment at all. It was a draft judgment which he had kept ready, but was not delivered. He died before the judgment was pronounced. It was published by his son much later. Further, the judgment had been reserved after argument, and before it was delivered, there was some procedural flaws then prevailing in England, because of which the petition abated. Therefore, it's a judgment never delivered in court in a case that had already abated. The entire law of criminal contempt is shrouded in uncertainty and vagueness. While one may accept constraints imposed by law, it's difficult to appreciate and accept ad hoc rules imposed by the vagaries and idiosyncrasies of individuals. In fact, that is the very antithesis of the rule of law. All this is anachronistic and out of tune with the constitutional democratic ethos. As we all know, we got this law from England, but in 2012, the Law Commission recommended abolition of this, and in 2013, the scandalizing the judiciary has been abolished in England. If judges decay, contempt power will not save them, remarked Justice Krishna Iyer rightly and wisely. And he went on to say, and so on the other side of the coin, the judges, like Caesar's wife, must be above suspicion. I am convinced that democratic institutions, including the court and judges, must suffer criticism and benefit from it. And he put it in his inimitable style. Many an arrow at random sent hits a mark the archer never meant. Ex cathedra generalizations run the genetic risk of noetic imperfections. The Almighty does not share his omniscience with the judiciary. In many countries, this jurisdiction is regarded as antiquated and sparingly exercised. It is not used to silence comments on judges or legal matters. To speak of the judge's ignorance of law or of an improper conduct may be intemperate criticism, not contempt. That respect for the judiciary can be won by shielding judges from criticism is a misconception. Muscling criticism against judges and judgments will not preserve public confidence in courts or enhance their dignity. That is preserved and enhanced by the work the court does, by its professional competence and moral integrity. It does not depend on what people are publicly allowed to say about it. Rather, it would depend upon and would have to be measured by the institution's response to what is said. As Chief Justice Warren Burger warned, a court which is final and unreviewable needs more careful scrutiny than any other. Unreviewable power is the most likely to self-indulge itself and the least likely to engage in dispassionate self-analysis. In a country like ours, no public institution or the people who operate it can ever be above public debate. Justice Douglas remarked, and this remark has been quoted in almost every judgment, that judges are supposed to be men of fortitude, able to thrive in a hardy climate, who should be able to shrug off contemptuous statements. Our courts have done so on many occasions. But unfortunately, there have also been instances of the courts being oversensitive, which is neither necessary nor desirable. That is nothing but contempt powers being designed to try to maintain a good public image. The attitude and ability to shrug off is what is really required and commendable. There are also anachronistic misconceptions about legislative privileges in India. Well, I would not touch upon this for want of time, except to say that the sage counsel that Chief Justice Gajendra Gadkar administered at the end of that judgment in Keshav Singh commends itself and is applicable to all repositories of power. The vindication of the rights of the citizen against repressive authority by whomsoever exercised is verily the protection and integrity of the Constitution itself. As Benjamin Franklin observed, and which the Supreme Court has quoted, freedom of speech is a principal pillar of a free government. When this support is taken away, the constitution of a free society is dissolved and tyranny is erected on its ruins. It is against this that we should always be on the guard and resolutely set our face against. Nightfall does not come at once, nor does oppression. In both instances, there is a twilight when everything remains seemingly unchanged. It is in such twilight that we must all be aware of the change in the air, however slight, lest we become unwitting victims of the darkness. At the end of the day, in matters like this, it is not very material as to what the law or the governments prescribe. Lord Acton said, the great thing is not what is prescribed, but what ought to be prescribed. For no prescription is valid against the conscience of mankind. Conscience, Washington said, that little spark of celestial fire called conscience. And the father of the nation perceptively remarked, there is a higher court than all courts of justice, that is the court of conscience. Thank you very much for your patience and courtesy.
Thank you, sir. I think we will leave the floor open for questions.
I hope I have not exceeded my time.
No, sir. In fact, I was expecting a little more.
It's 1 hour now. Yeah.
Certainly. We will leave the floor open for questions.
Yes,
Whoever
sir.
have a question, please either make a comment on the chat box, or you can raise your hand using the option for the same in the Zoom platform.
And I hope I was audible thereafter.
Yes, sir. Yes, sir.
Yeah.
Mostly the second portion when reading.
Yeah. Sorry for the disturbance.
Hello.
Yes, you are audible, please.
So you told a sentence about legal language, repeated a term.
Which one?
You told that mark a term, like mark a sentence. You told me, right? Told us. You explained a sentence. Language is something.
I think.
Repeated that sentence like that.
Pardon.
I think Madhurima is referring to the judgment of the Honorable House of Lords, where they said
yes.
they referred to language.
Yeah. Lord Bridges' opinion.
Yes, sir. Yes, sir.
Yeah. So what do you? I mean, what's the question, please?
Can you repeat that
Okay.
sentence? Once
Yeah.
again?
Sure. This is what Lord Bridge said. I cannot conclude this opinion without disclosing that I have had the advantage since the conclusion of the arguments in this appeal of reading an article by Professor Glanville Williams. Okay, that's the fact. Then the sentences you are interested in follow. The language in which he criticizes the decision in Anderton versus Ryan is not conspicuous for its moderation, but it would be foolish on that account not to recognize the force of the criticism and churlish not to acknowledge the assistance I have derived from it. This is R versus Shivpuri, 1987 appeal cases, page 1. And the criticism of Professor Glanville Williams, you will get it in 45 Cambridge Law Journal, page 33.
So referring to the same, if I am permitted to raise a question, we hardly find any reference to any academic writing in any of our judgments, either from the High Court or from the Supreme Court for that matter. When an issue is already decided, is either reconsidered or again.
You have. Fortunately, we have. We have reference to Durgadas Basu, you have reference to Sirvai, at least these two.
That is there.
On their treatises on the Constitution, we have references. I think it would be fruitful to have more references. In fact, just to carry that further, I forget the citation, but under the Hindu Succession Act, Section 14, there's a judgment in 1975 and there's a judgment in 1976, or in 1976 and 1977. Justice Murtaza Fazal Ali very graciously acknowledges that he was under a mistaken notion in his earlier judgment, and after he read the commentary of Colebrook's Digest of Cases, he was enlightened and changed his view a year later. So we have such instances.
May I ask one question?
Sure, please do.
Hello, sir. I am Ashok Kini, practicing in High Court.
Please.
My question is very simple. In the sense, there is a section 2C that is scandalizing of court.
Yeah. Yes.
In UK Parliament, it has been abolished. Do you think that the legislature should come forward and have this section repealed or so?
I have not the slightest doubt that it is long overdue. Even if it remains on the statute book, it must be treated like a dead letter confined to the dustbin of history. That alone would be wisdom.
Yes, sir. What, according to you, stops legislature from doing so?
That is a question which I am incompetent to answer. I have not had the fortune of being in the legislature.
I am asking this because
Yeah.
in fact I
Please,
think
please.
there
I mean, that was in a lighter vein. Forget it. Yeah, please. Yeah.
in fact I have learned that parliament and legislatures have also this constitutional power of taking contempt, but they are not exercising it as
Yes.
frequently as the courts do.
Yes.
And
And if they exercise, you still have the power of judicial review vested in the courts, even though to a limited extent, against the exercise of power by the legislature, if it tramples upon your fundamental rights. Well, it's a matter which they should address themselves.
But a petition has been filed in Supreme Court and withdrawn also now.
Yeah, that's what I also read in the newspaper.
Lakshmi sir?
No, we acknowledge the graceful.
That way, I'll just leave you with one final thought.
Sir.
In a lecture on the judiciary and the media, delivered at Jerusalem on 28th March 2011 by the then Lord Chief Justice of England and Wales, Lord Iger Judge, he commended to all judges everywhere the wise words of Michael de Montaigne, a great writer of Renaissance period in France. And these are the words, I think with that thought, I will leave you. No matter that we mount on stilts, we must still walk on our own legs. And on the highest throne in the world, we still sit only on our own bottom. Thank you.
If there are no further questions, I would request our Executive Committee member, Advocate Navaneet D. Pai, to propose the vote of thanks.
Before that, Hari, 1 second. Before that, we acknowledge with extreme happiness the kind presence of Justice Ramakrishnan from, our former judge of the Honorable High Court of Kerala. And sir, I am very thankful to you for your kind presence, graceful presence, sir.
Thank you very much. I am late on joining, but anyhow, I heard the last portion of Learned Counsel Pai's the lecture.
Sir.
Yes. Anyhow, during the pandemic period, you are taking a lead in providing some thought-provoking subjects, I can say, because always on the controversial area. Anyhow, because everything, freedom of speech is always the thought of the people. Where is the boundary line for that is yet to be determined. So that is always there. That is always left to the judiciary to decide as to whether that crosses the boundary line or not.
Definitely, yes.
Okay, thank you very much.
Thank you, sir.
Sudheesh, now I am having a sitting up to 5 o'clock, so only thereafter I could come. And by the time I come, almost the last portion, I was able to hear it.
Sudheesh Pai, sir.
Yes, sir.
May I ask one question, though it may be sometimes it may be sub judice. I just wanted, very curious to know about the legal implication of the last verdict in Prashant Bhushan, Advocate Prashant Bhushan case. On the eve of the Independence Day, the Honorable Supreme Court handed down a verdict. So it raises mixed feelings among the citizens. This is my perception, it's my thinking. Can you comment anything on that? I'm not saying that, as rightly just observed by Justice Ramakrishnan, sir, that it's a controversial area. But controversy or non-controversy, we must address it.
With the utmost respect, there is nothing controversial. All that I have said answers your question. And there can be no mixed reactions. There can be only one reaction. God bless India.
Yes, sir.
I hope I have conveyed my answer.
Definitely, yes.
Please remember that in 1936, President Roosevelt made a very meaningful statement. 9th March 1936 in a radio address to the United States people, where he said, well, I'm not saying it, I'm just quoting him, where he said, we must find a means of taking an appeal to the Constitution to save the Constitution from the court and the court from its judges. That was Franklin Delano Roosevelt, the President of the United States of America. Thank you.
Thank you, sir.
Thank you so much, sir. May I now invite Advocate Navaneeth to express the vote of thanks.
Good evening, all. I deem it a great honor and privilege to propose the vote of thanks on this memorable occasion. Let me start by acknowledging glory to the Almighty God for making today's continuing legal education program a resounding success. I thank our special guest, V. Sudheesh Pai, renowned jurist and author, who despite his busy schedule has found time to grace his continuing legal education program. I thank all the judges of this honorable court, former judges, Justice Ramakrishnan sir, senior advocates, junior advocates, law and media students, and other invitees for attending this talk. I also express my heartfelt thanks to Advocate R. Lakshmi Narayanan, President, and Advocate T.K. Ajit Kumar, Secretary, Kerala High Court Advocate Association, for their valuable support and contribution. Finally, I leave you this inspiring quote by Martin Luther King. An individual has not started living until he rises above the confines of his individualistic concerns to the broader concerns of all humanity. Once again, I thank you all for your attention. Thank you.
Thank you, everybody. And once again, on behalf of the association, I apologize for the inconvenience caused at the beginning. Thank you so much, sir, for being here with us. We will conclude the meeting. Lakshmi, sir.
Thank you, everyone. Thank you.
Thank
We will
you.
meet
Thank
soon
you.
again. Thank you, sir. Thank you, sir. Very kind of you.